Are you getting ready to head into the courtroom for your child custody case? Are you feeling terrified because you have no idea what to do once you set foot into the courtroom? Well, if this is you, don't worry, because I'm going to break it down for you right here, right now, in this video. If you're not already a Command the Courtroom subscriber, hit the subscribe button, hit the notification bell so you get notified when new videos drop, and also check out the hundreds of other videos on the Command the Courtroom channel. My name is Wendy Hernandez, and I've been practicing law for 25 years. I'm a Phoenix family law attorney, and I'm also the creator of Command the Courtroom. My passion is helping people navigate the courtroom so they can get a child custody result that's in the best interest of the children. All right, so let's get down to business. Let's talk about what happens in a child custody hearing. For starters, I want you to understand what it means to have a hearing in front of a judge. So when you hear the word hearing, that may make no sense to you. You may hear the word trial, and maybe that makes a little more sense to you because you're used to seeing trials in movies and courtroom dramas. In a lot of cases, hearings and trials are the same thing. They're also the same thing as evidentiary hearings. So what you need to understand is, are you going into the courtroom where witnesses are going to testify and where evidence is going to be presented? If that's the case, you're in the right place watching this video. So let's talk about what happens in a trial, an evidentiary hearing, or a hearing where witnesses are going to testify. And also keep in mind that a hearing might be a final hearing or it might be a temporary orders hearing. All right, so there's four main parts to a hearing. The first part is the opening statement. The second part is where the first party presents their case in chief. Then next, the second party presents their case in chief, and then there are closing arguments. So the sandwich is where the parties are presenting their case. That's where the meat of things happen. And I'm going to break down even further what happens during the meat of the case or during the meat of the hearing. But first, let's talk about opening statements. So an opening statement is just that. It's a statement of what you think the evidence is going to show at the hearing. An opening statement is not evidence. It just gives the judge a preview of what you think the witnesses are going to say, what you think the documents are going to show, and the conclusion that you think the judge should reach based on this information. But again, it's not argument. Your time for argument is at the very end of the case, and we'll talk about that later. Now, in my jurisdiction, where I practice in Phoenix, Arizona, most family law attorneys don't present opening statements. I've presented opening statements a handful of times over the years because we have such limited time to present our cases to the judge. I just want to get straight to the evidence. I don't want to spend time doing an opening statement. You have to know the rules in your jurisdiction. You have to know what the judges expect. You have to know kind of what the local manner of proceeding is. If judges in your jurisdiction expect an opening statement, then you need to prepare one. Now, in preparing your opening statement, what I recommend is you take a look at your pretrial statement that you probably had to prepare for your judge, and you kind of follow the outline of your pretrial statement. And by the way, yes, I do have videos on what pretrial statements are and how important they are to your case. Your pretrial statement, just like the opening statement, is an outline of what you expect the evidence to present. So use that pretrial statement in crafting your opening statement to the court if you have to present an opening statement. After opening statements have been done, then the party who filed the current pending motion or petition has to present their case in chief. So if you are the one that filed the current pending motion or petition, then you have to present your witnesses first. And if you don't have an attorney representing you, then you're going to have to get up on the stand and you're going to have to testify in narrative form. So what that means is nobody's going to be asking you questions. The judge may have some questions of you. So it's going to be up to you to outline for the judge what your position is on each of the issues in dispute. This can be challenging because guess what? When you're in the courtroom, you cannot read from your notes. You cannot read from a statement. If you forget something and you have notes that will refresh your recollection, you can ask the judge to refer to your notes, but you have to ask permission. So you're going to have to be pretty organized heading onto the stand about what the testimony is going to be and what documents or what evidence supports that testimony. Another tip, keep in mind that Your documents and evidence actually have to be admitted into evidence for the judge to consider them. The fact that the clerk has just marked your evidence isn't enough for the judge to consider it. It has to actually be admitted. There's another Command the Courtroom video on admitting evidence, but be sure and admit the evidence that you want the judge to look at and that you think is most critical to your case. So once you're done testifying, then the other party or the other attorney is going to get a chance to cross-examine you. What that means is they're going to try to reveal weaknesses in your case or reveal holes in your case or try to catch you in lies. That's called impeaching. And they're going to lead you with questions that require a yes or no answer. These are called leading questions. This is not unusual. Don't freak out though. If the other attorney or the other party leads you into a yes or no question that you don't think tells the whole story, you're going to get to come back and testify again during rehabilitation. And at that point, you can explain an answer that you didn't get the chance to explain during cross-examination. So this process is the same. It repeats itself for each of your witnesses. If there's anybody else besides you testifying, then you would call that person to the stand. You would ask them questions. As they're testifying, you would introduce the relevant exhibits to the court, and hopefully the court will admit them. Then the other side will get to cross-examine your witness, and you'll get to come back and rehabilitate the witness if you feel like any answers need to be cleared up or that the other side hurt them with cross-examination questions. Once you're finished with all of your witnesses, then you rest your case. So as you're watching this video, bells and whistles are probably going off in your head and you're thinking about, what about this? What about that? What about this? What about that? And if you have other burning questions that you want me to answer or possibly do videos on, be sure and type them in the comments below. Okay, so let's go on to what happens next. The opposing side gets to present their case in chief. So the opposing party is going to get to testify, and if they're representing themselves, then they will get on the stand and testify in a narrative form. They'll introduce evidence and exhibits, and you'll get the chance to cross-examine. You'll get the chance to ask leading questions. You'll get the chance to poke holes in their testimony or in their story or in their case theory. And then, of course, the other side will get the chance to rehabilitate themselves after you've crossed them. The other party will then go through this process for each and every one of their witnesses. They'll call the witness will be questioned, you'll get the chance to cross-examine, the witness will get to be rehabilitated. Now, in some jurisdictions, judges are allowed to ask questions of the witnesses, and many judges do in my jurisdiction in Phoenix, Arizona. And if judges ask witnesses questions, then usually the judge will give each party the chance to ask follow-up questions to the judge's questions. So once the responding party has had the chance to present their case in chief, then the party who initiated the petition can present rebuttal witnesses and rebuttal evidence. I have to be honest, though, in 9 out of 10 cases that I have, I don't present rebuttal witnesses and I don't present rebuttal evidence. But once in a while, when the other side made a point that I feel like, okay, we need to rebut this, I will call an additional witness or call my client to the stand again, or I'll present another piece of evidence. And you have the opportunity to do that. If you do present a witness on rebuttal, then the process works just the same. You would call that person during direct examination. You would ask them questions. The other side would get to cross-examine the witness. You'd get to rehabilitate the witness, and then that would be that. After all the evidence is presented, then it's time for closing arguments. Closing arguments aren't evidence either, but at this point you can argue to the judge. You can tell the judge, hey, exhibit X, Y, and Z was admitted. This witness testified to A, B, and C. And this is what the law says, judge. And because of these two things, and because the law is in my favor, you should find in my favor on all of these issues. Now, you can prepare your closing argument in advance of the trial. A lot of times people think, I can't prepare a closing argument ahead of time because I don't know what's going to come out. That's not true. If you've done your homework, you've done your disclosure ahead of time, you've done your discovery ahead of time, you can anticipate what the other side is going to present, what their witnesses are going to say, what evidence is going to be admitted, and you can at least do a rough sketch or a rough outline of the closing argument that you want to present. And I'd recommend that you do that because otherwise it comes off as disorganized, like you're just throwing spaghetti at the wall. You really need to be clear when you're talking to your judge. The judge is not a mind reader. In order for the judge to do what you want him or her to do, not only do you have to be clear, but you have to convince the judge why the law is on your side. So the further in advance you could prepare, the better for you, the better for the judge, the better for your case. All right, so that is the rough outline of what happens once you set foot into the courtroom for your custody hearing. There's a lot more that goes into preparing for a custody hearing and actually conducting the custody hearing. And if you want to find out more, then hit the subscribe button, hit the little bell, check out all the videos on Command the Courtroom. If you like this video, give it a thumbs up. And remember, until next time, don't give up, get prepared, keep on trucking, get out there and command the courtroom.